Question, tell me what you think about me. I buy my own diamonds and I buy my own rings. Only ring your celly when I'm feeling.
Hello, everyone, and welcome. I'm your host, Joanna Recinos with the Real Estate Talk, and I am super excited about today's show because we have our first guest. This particular individual is someone I definitely wanted to have on as a first guest because not only is he a great friend and he's helped many of my clients, I just feel he goes hand in hand with what we're facing in today's economy, which is this global pandemic that we're still facing. And this gentleman is actually helping a lot of families going through situations as a result of this. This particular gentleman has been in the law field for about 12 years. He specifically focuses on probates and estate planning, along with involving any litigations with trust and estate. So without further ado, I'd like to introduce Mr. Dorian Jackson. Hello, Dorian, and welcome.
Thank you, Joanna, for having me. Pleasure to be here.
No, likewise. Thank you for taking the time out of your busy schedule to be here with us. So as I mentioned, you're obviously a big part of what's going on and trying to help families with what we're facing in today's world. So why don't you share with us a little bit about you and what made you go into this particular aspect of law?
Well, when I was in law school, I think wills and trusts was my favorite course, and I sort of just fell into it, into practice. And as I got more into it, I realized, this is what I really enjoyed, so I just kind of pushed further into it. So it's sort of like, I think most things in life, you sort of do many things until you find something you like, and then once you find something you like, you pursue it.
Awesome. Excellent. So can you tell us a little bit more about estate planning and why it's so important in order to avoid a probate sale?
Right. So particularly from a real estate standpoint, living trusts are incredibly important. With estate planning, there's many different estate planning vehicles. Now, the living trust is the premier estate planning vehicle because it's the one that gives you the most control and avoids probate. Now, most people believe that a will avoids probate. This is simply incorrect. A will still has to go through probate. The difference between a will and not having any estate plan at all is with the will, you can decide who's in charge and who gets what. Whereas if you don't have that, the state decides for you, basically. So when you have a trust, you can put the property into the trust, and then you can expediently sell the property after the elder passes away, as opposed to going through probate, either with a will or with no estate plan at all, where it's going to take several months before you'll be ready to sell the property.
Thank you for touching on that. I'm so glad you touched on that because there's always a confusion as to what is the difference between the two. And it's obviously very important to know that. Now, as far as what we're facing, obviously in today's world, what are your best tips for someone who has an unexpected loss of a loved one, and obviously they have either a property or several properties involved, that are left behind to the family to deal with?
Well, I would say step number one is find out if they have an estate plan at all. Sometimes that may be easy, sometimes that may be difficult. It really depends on the relation and how close they are. Usually the closer they are with the elder, they're probably more likely to be aware of an estate plan. But if they're a little bit more remote, they're less likely. So that sort of leads me to the second step, which is to check title. And if they don't have the ability to check title, which is probably difficult right now, given the pandemic, because you can only go into the county recorder's office with an appointment. Mm-hmm. Pre-pandemic, it was easy to go into the recorder's office. You could just stroll in at any point in time, hop on the computers and search title. Now you have to have an appointment to get in. So it's made it a little bit more difficult for those who don't have access to real property records online, which are usually through secure databases, which you need to have access to. So in that regard, I would say to contact someone like yourself as a real estate agent, a title representative, or someone like myself who has connections to title representatives to check the title, because usually if there's a trust, the property will be titled in the trust. So that's usually a good indication of where to start as well. And then after those two things, I would say you need to make sure you go through the elder's property and look for any bills, any debts. And then you also need to ascertain who the either heirs, assuming there's a will or a trust, or beneficiaries, assuming that there's a will or trust, or if there is no will or trust and they die, which is referred to as intestate, meaning without an estate plan, the biological heirs, which can be a little bit tricky. So that's probably another situation why you'd want to contact someone like myself to help guide you through this process.
Got it. Got it. Well, those are definitely some great tips. Now, as far as someone, obviously I'm a minority, we're both minorities. And when it comes to families and what's left behind for the families, sometimes the adults, the parents often think, well, it's left for my kids to this property. Once I'm gone, it belongs to my kids. And they don't normally prepare and plan with estate plannings or a will. What would you recommend for someone who's in that situation? What is the first step for them to take should something unexpected happen to their family and they don't know what to do with their property?
Are you talking about in the sense of they're incapacitated or deceased?
No, in the sense of parent or the homeowner passes away, wife is left behind and children, automatically they think that the property is left behind to the wife. Right. And it's not always the case, right?
Correct. So I think in that situation, I think the surviving spouse, usually it's the wife, sometimes, but a little less rarely, it's the male, unfortunately for me. In those situations, I think what you should do is, again, check title. And I think this is particularly important for Latino communities because generally older generations in Latino communities tend to be a bit machismo, where the man sort of controls everything and has title to the property, even though he's married. I've seen that several times personally, where an older Latino couple thought they owned the property. Husband dies and wife realizes she has to go to probate because she was never on title with the husband. So it particularly, I think in I would say ethnic communities that the older generations tend to be a little bit more patriarchal, I would definitely say make sure you look at title, because title may not be the way you think. And that's sort of just to take a step back from the particulars of your question, that's sort of an overarching point, because I often have clients for estate planning and I ask them how they take title to the property. No one knows.
Yeah, because there's different manners in which you can hold title, right?
Correct. And very rarely does a layperson ever know how they have title, because I've had numerous clients tell me, oh, yeah, this is how I have title. And then I pull title and I'm like, no, it's not. So that's why as estate planning attorneys, it's pretty much malpractice if you're doing an estate plan for a client not to pull title. Because if you go based on your client's representation, you're probably going to be making a mistake.
Got it. Okay, great. Now, once, say someone does have estate planning and there's a will in place, what is the big difference in someone needing to sell a property, right? Whether they have a trust or no trust? What are the implications involved if you do have one versus not having one and you need to sell a property?
So that I actually do a little course on this for real estate agents as well, about the basics of selling property through trust and estates. So I would say there's pretty much two main tracks. One of the tracks sort of has a slight offshoot, but you have estate planning track, which is if you have a trust. Mm-hmm. Then you have the other track, which is probate, which can be either will or intestate. Okay. So remember, just to emphasize this point again, and I want to destroy this misconception because it's a very prevalent misconception. A will does not bypass probate. So if you have a will, you are in probate if you have a will and nothing else.
Got it.
So once you're in probate, it's a little bit more complicated because when you're in probate, you have to file the initial petition. Assuming no one objects, then you're approved. Now the problem becomes getting the order and then the letters. Now letters is a term of art. It's a document that illegally entitles the personal representative to act on behalf of the estate. Without this document, legally speaking, you have no authority to act on behalf of the decedent's estate. Now, the problem becomes even further now in this pandemic, because if you're in LA County, you're not getting letters probably for 4 to 5 months because of the delay in the probate attorney's office. So this is just inside baseball for you, but because I do this all the time, but the probate attorney's office in LA County is incredibly short-staffed. They got hammered with COVID and Omicron. So they don't have a lot of attorneys, and it's taking a very long time to get orders. I just recently got an order a couple of weeks ago for something that got approved in like October of last year.
Wow.
So if you're in probate nowadays with COVID, you're going to expect long delays, because if you don't get that order, you can't get the letters. Until you get the letters, you can't act. So if you need to talk to the lender won't talk to you. Okay. If you need to sell the property, you can't sell the property. Right? You really can't do anything. And let me just backtrack for 1 second, because I just thought of something else that's very important. If someone does die and you're trying to figure out what to do, please do not contact the lender until you have contacted a probate attorney. Because one of the worst things that you can do is contact a lender before you have your ducks in a row. Because if you do, a lot of times, particularly in the context of a reverse mortgage, the lender will immediately start foreclosure proceedings. Now, given the delays that you have, you're going to have to spend more money, because you're going to have to go in, which is referred to as ex parte, which is on an expedited basis, to try to get temporary letters so that you can talk to them and work it out with them, or possibly even sell the property, which is rare with temporary letters, but it might be possible. So with the probate track, whether will or no will, that's sort of how you go down. Now, it gets more complicated if you don't have what's referred to as IAEA authority, which stands for the Independent Administration of Estates Act. Now, if you have that authority, your life becomes a lot easier when selling a property through probate, even though it still takes time. But if you don't have that authority, you have to do what's called a petition to confirm the sale, which is a whole nother long procedure, because you're not getting a hearing date for that in LA County for about 4 months.
And what does it take to get that authority that you just talked about?
That's a very complicated process. Basically, I think what the easiest way to say it is, I think you need an attorney like myself who's experienced, who knows how to work with multiple people that may not necessarily either get along or even trust each other, because a lot of times there's sibling rivalries, and there's very deep-seated inherent distrust.
And that's a very important aspect that you're touching on, because when a loved one is gone, reality, we know that's when the claws come out, right? That's when everyone wants to fight for the estate. So having someone like yourself is definitely the ideal way to go.
Definitely. And even possibly before that, because a lot of times that's when the nefarious activity goes on, where, maybe, Abuela is older and she's losing her memory a little bit. And then all of a sudden someone gets her to sign a document, and lo and behold, they're the sole owner of the property. So there's various sides to it, but it's harder when you go through probate. Now, if you have a trust, it's real simple. You send the notice, worst case scenario, you wait 120 days, you can sell the property. But even before then, you can sell the property and just hold on to the money, or you can have them sign a waiver of their right to contest and sell the property. So it's an expedited procedure when you have a trust. And honestly, I'm surprised more real estate agents aren't like yourself and kind of encouraging clients to get trust more, because as a real estate agent, you generally get residual business, meaning that you represent a client once, they're happy with you, they come back, and then you do another transaction for them. Right?
Of course, right.
So if they have a trust in place, it makes it easy for you as an agent to get that next sale.
Yes, it definitely does. It definitely does. And that's why I wanted to have you be part of the show, because with what we're facing today, I mean, so many families are running into that particular situation where there's no estate planning. And oftentimes people don't know where to go. They don't know where to start, and like you said, there's a lot of realtors also out there that are not familiar with the process. And I'm sure you've probably ran into situations yourself where you're helping a client, but they're working with someone who's done what they're not supposed to in the sense of putting the home on the market when it's not ready to be on the market.
Oh yeah, that's the reason I created that little PowerPoint for real estate agents about the basics of selling the property. I mean, I would say 95% of the referrals that I get from real estate agents are the following type of scenario. An agent calls me, says they're about to close in a week or 2 weeks, right? They just got something from title saying they need an order from the probate court, and they want to know, can I get it for them in time to close the transaction?
That's
right?
terrible.
That's like 90 to 95% of referrals from real estate agents that I get. And then I have to be the bearer of bad news and tell them, no, you're not going to get an order in 2 weeks, particularly with the delays from COVID. And, I feel their pain, but at the end of the day, it's not what the law refers to as an exigency just because you want to sell the property, right? You can wait and still sell the property, right? So it's happened quite a few times, and I've actually seen a realtor lose the client behind it and got fired and then lost the transaction. And then the client ended up turning around and selling the property to the same buyer himself. So
wow. Yeah, that's unbelievable. So that's why it's so important for us to stay on top of, educating our clients when it comes to, especially something like this, that's so, so important in today's world. Now, I want to ask you one other question, because I know there's probably families who have no idea or don't even know wills or estate planning exists. In a case where a family has, a loved one that passed away and the family's left behind and they're still making the mortgage payment, right? And they continue to make that mortgage payment and with no intentions to sell the property. What recommendation do you have for that type of individual? Like they still want to keep the property, but don't know what to do, but they assume, because we're paying the mortgage, no one knows that, dad or mom is no longer in existence.
Right. So in those situations, I would recommend going to probate as soon as possible. Now, part of what they're doing is not necessarily bad because, as I said before, you don't want to notify the lender right away because they usually start foreclosure proceedings.
Right.
But the thing that follows immediately thereafter is you need to promptly get the estate going so that you have a personal representative appointed so that you can talk to the lender. Now, if you're just paying the mortgage and months or years go by, you're creating a very big problem because I've also seen what people do in this situation is they have homeowners insurance. I've actually had this conversation several times where someone's like, oh yeah, I have homeowners insurance, we're protected. And then my first question to them is, well, who's on title as the owner of the property? And then they say the deceased person, right? But then they immediately say, but the homeowner insurance policy is in my name, right? And then my point is, well, exactly, that's the problem. The first thing that's going to happen when anything happens in that house and you try to file a claim is they're going to say, where's the elder, right? You're going to say they're dead. They're going to ask you for the death certificate, and then they're going to deny the claim. Now, the response I get is, well, why are they taking my money? And I was like, well, if you're going to give them money for free, they're not going to say no.
Of course.
Right? So, that doesn't really mean anything. So if you are paying a mortgage and you are not on title and no one else alive is on title, then you're creating a big problem because you have a valuable asset that is unprotected, meaning that there's no homeowners insurance that will cover any damage or loss. And then, God forbid, should the lender find out and start foreclosure proceedings, you're now behind the 8 ball because now you can't quickly sell the property or do something else. You have to go through all those probate procedures that I told you about earlier. So if you do have someone who had a regular mortgage, not a reverse mortgage, where there's actually monthly payments, and they're deceased, I would definitely say continue to make the payments because you can also be reimbursed for that through the estate. But you need to promptly thereafter open up the estate. Otherwise, you're creating a big problem that's probably going to lead to a very big loss down the line.
Got it. Got it. And maybe another reason why I asked this question is because someone who may be in that situation may not necessarily want to get rid of the property and they want to keep it. So just to clarify, if someone does go that route and they reach out to an attorney like yourself, they can still opt out to keep the property, right? Just as long as they go through the normal
Correct.
steps to
Yeah.
give them that ownership of the title of the property again.
Correct. They can keep the property. It's up to them whether they want to sell it or just, take title themselves. The only thing that I would say in that regard is then the attorney's fees would be paid directly. And another thing I want to address, because oftentimes people don't want to contact probate attorneys because they're afraid about the cost.
Yes.
The attorney's cost doesn't come out until the end. So it's not something that the client would ever pay up front. So if anyone is ever telling you up front and charging you for attorney's fees up front, they're violating the law. So I would
Wow.
immediately stop working with that person and go contact someone else.
I'm so
Because
glad you clarified that.
Yeah. So just to reiterate, they don't come until the end. So if you want to keep the property, there's mechanisms that we can use, whether it be a HELOC, a refinance, or maybe they have the liquidity and they could pay it themselves, right? Either way,
Right.
there's options. But I'll just give you one other example. I was recently in a department in Riverside County Superior Court, and the judge implored in pro pers to not represent themselves because he said, and this is his words, that it's going to be impossible for them to figure out how to do this on their own, having not done this before, because it's just such a complicated web of statutes. And if you haven't done it before, it's incredibly arduous, if not impossible. And this was a judge who sits on the probate bench, who was basically trying to convince in pro pers to not represent themselves, and he was sending them to the County Bar Association to help them find an attorney.
So this is again another terms, individuals trying to represent themselves to
Correct.
avoid attorney fees.
Yeah,
Wow. I can't believe there's even people that would try to do that. I mean, like you said, there's so many laws and implications behind this for someone to try to do it on their own. I mean, I wouldn't even recommend it, and I'm not an attorney.
yes, it takes a while to really get the lay of the land, and if you don't, it's going to lead to a long delay. I mean, I've seen people who haven't even got to the appointment stage, which is literally the first stage. So I like to divide probate into 3 stages. It's getting the personal representative appointed, administering the estate, and closing the estate, right? Those are like the 3 big steps of probate as why I like to break it up. The first step is the appointment. And I've seen people go years, like 1 to 2 years of not being appointed and just continually having hearings because they keep trying to do it on their own and they can't figure out all of the legal requirements.
And who decides who gets appointed? Do they choose amongst the family, or is that?
Well, it depends on the petition. So someone has to petition for someone to be appointed. Now, you can petition for yourself to be appointed, or you can petition for someone else to be appointed. But someone has to petition, in other words, institute an action, well, not an action, it's not adversarial, but institute a legal proceeding such that you want the estate to be administered. Now, there's a statutory scheme of priority as to who has priority of appointment. I believe it usually goes spouse, child, parent, sibling, and so on and so forth.
Okay.
But usually, if the spouse is alive, she has priority. If there's no spouse and the kids are alive, they have priority. So usually it's pretty clear. It's only a matter of which kid wants to do it. And sometimes you do have fights, like, for example.
Yeah, that's what I was going to ask. Who gets to choose what kid, because
right.
one might not trust the other. So that's a tough situation. And I think that's where it boils down to that, it causes problems amongst the families.
Correct. And I think I think that's a very sticky situation because ultimately the court is going to decide.
Okay.
But at that point in time, it's a contested matter. So normally an administration of estate is not adversarial, meaning it's not like your normal lawsuit that you think of when you watch like TV, right? Like
Right.
Joe Schmo isn't suing, Susie Spandex, right? It's just, it's you're just administering estate. In other words, we're paying off the decedent's debts, we're marshaling all the assets, and then we're distributing the proceeds to the heirs or the beneficiaries, right? That's in essence all an estate is. There's nothing adversarial about that. Now, when two people are fighting over who should be in charge, it now becomes adversarial, meaning that you have a trial, okay? The cost now goes up tremendously, okay? And ultimately the judge is going to decide. And the problem is this is where the mudslinging starts, because in order to knock someone out from being appointed, there's certain statutory benchmarks that you look for. And that's usually when you start slinging the mud to try to, not get someone else appointed so that you yourself can get appointed. And also you have the possibility of the bond issue, because you have to get a bond as well. So, with a bond, you have to look at the person's credit, you have to look at their income, you have to look at the assets. So, some people may not be able to obtain a bond, especially of a certain value. So there's several things that go into it, but ultimately the court is going to decide that at the end of the day, the heirs or the beneficiaries don't win, the attorneys do.
Got it. Wow. There's definitely so many implications behind it all. So, for someone who wants to reach out to you or needs advice, what is the best way for them to get a hold of you?
They can call our main line. We have offices in 5 counties right now. So we have LA, Riverside, San Bernardino, Orange County, and San Diego. So, they can call any of our main line numbers. Our main corporate headquarters is in Torrance, and the main line there is 310-359-9201. So they can reach out to us there if they have any questions or concerns and schedule a consultation.
Awesome. Well, we'll make sure to have your information down so to make it easily accessible to those guests that are watching. And well, before I let you go, what's the biggest tip that you have for our community out there right now, and what they should be doing to make sure they protect their biggest asset, which is their homes?
I would say talk to an estate planning attorney and get your estate plan in order. It's not just the home and the trust, which is important, especially given the meteoric rise of real estate values right now, because a lot of low income communities, or I should say communities that were previously low income, right, have now completely changed. So like South LA, East LA, Boyle Heights, right? Those were all neighborhoods that you could 6-7 years ago buy a home for like 200,000, maybe even less, right? Now, they're like $700,000-$800,000 to buy a home in these neighborhoods. So with this huge rise in property value, there's a lot of wealth that's being developed. But if you don't know how to retain that wealth and pass that wealth on to the next generation, then ultimately it's going to create more issues. But also just remember, it's not just property, right? You have other issues, like what happens if you become incapacitated, right? Which is another reason why a trust is more important than a will, because a will only operates upon death. If you're incapacitated, they can't do anything to the will until you die. Whereas with the trust, it can operate upon incapacity. So that's another benefit to a trust. And then in addition, you should have a power of attorney, because what happens if some assets are in your name personally and not in the trust? So it's important to remember, think of the trust like a basket. The trust only controls what's in the basket. If you don't put the stuff in the basket, then the trust can't control it. So that's why a power of attorney is important, because if anything is retained in the elder's name, the power of attorney would then give you the action to reach that asset. And similarly, for healthcare, you have the Advanced Healthcare Directive. So that's also for healthcare decisions. Like if you're incapacitated, who makes the decisions? Do you want to be kept alive? Do you want them to pull the plug? Do you want to donate your body for science? All these important decisions that you can make that make your lives a lot easier. Because here's another important thing that most people don't realize. generally one spouse does not have a legal right to make medical decisions for the other spouse. And if you don't have an advanced healthcare directive, that can be problematic. And I've seen it happen.
Wow.
And in one personal situation, a close friend of mine, her stepfather was injured in an attack. He went into a coma. Her mother, who was the spouse, was making all the medical decisions until the mother-in-law, who hated her, found out that they technically weren't married because she never divorced her prior husband. So they went through the divorce proceedings, but they never got the final judgment of dissolution. And most people don't realize, technically speaking, you're not divorced until the judgment of dissolution is filed, because that's the final division of not only the marriage, but the community property assets, right? So until that happens, you're not divorced. And she had the document but never filed it. So technically speaking, that she was not the spouse, because, we don't have polygamy here. You can't marry more than one person at a time.
Right.
So in essence, at that point in time, the hospital stopped taking direction from her as the spouse.
Oh my God, how
and then started taking direction from the mother, who then moved her son, which was her husband, out of state. So it's important to have the entire estate planning package done. So that way, in any set of circumstances, you'll be protected. And if you don't, it can lead to a lot of problems. And I've seen a lot of, unfortunately, bad things happen to good people. So.
Yeah, that's unfortunate. That's unfortunate. Wow. Well, awesome. Thank you so much, Dorian. You definitely cleared up a lot of doubts that families may have right now, especially like you said, it's not just for the property, it's for a person's, overall life decisions, whether it be finances, health, you name it. But thank you so much for being here today and giving us an insight on why estate planning is so important. And just so we know, generally, so someone has an idea, and I know it's going to vary from family to family, to get to meet with you. Is there a charge for a consultation? Do you do free consultations, or do you?
No, I generally do consultations for free. Especially because, with the telephone or Zoom, it's really easy and convenient to just quickly hop on the phone or do a Zoom meeting with someone, to make it, convenient and quick. Because, a lot of people, you have kids, you're married, traffic. So it's kind of difficult for a lot of people to get around nowadays, especially with COVID. So I try to make it as easy as possible. So yeah, we generally do consultations free. They're usually about 15 minutes for the free consultation. Then by that time, I'll usually have an idea of what the appropriate step is to take, and I can give them some sort of indication as to the pricing.
Okay, excellent. Awesome. Well, there you have it, folks. Thank you so much for joining us. And don't forget to download the Lux TV app so you can have full access to the episode. And if you need any help, guidance with it when it comes to estate planning, Dorian is amazing. He's actually helped several of my clients, and I strongly, strongly encourage you to reach out to him if you have any doubts or questions, concerns regarding your biggest assets. Thank you so much, Dorian. It was a pleasure having you.
Yeah, same here. Thank you.
Excellent.
Glutathione is a big word. It's the body's own master antioxidant. It's a scavenger for free radical, bacteria, and viruses. There are no products in the market with the ingredient NASET. NASET increases the production of glutathione that's in our body already to strengthen and enhance our immune system, elevate sense of well-being, support muscle strength and endurance, cognitive function, and liver support. It helps with increased energy and blood sugar regulation. Get your bottle of GSH Plus from